Bamberger. Today we're going to work a simulated multi-state bar examination type of problem in the area of evidence. It's problem Evidence2 over at my website www.profbamberger.com. If you haven't already worked problem Evidence2, why not take a moment, pause this presentation, go over to www.profbamberger.com, spend about 1:45 minutes working problem Evidence2, and then resume this presentation. Okay, the correct answer to problem Evidence2 over at my website is choice B. Upon timely objection by Metrofire, the court should rule the testimony of Stump admissible to impeach Tim. This is a really difficult evidence problem, and it's important to take a very analytic approach to it. You're analyzing a piece of evidence for admissibility. The very first thing you need to do is decide why that evidence is relevant. Under Rule 402, relevant evidence is generally admissible, irrelevant evidence is inadmissible. So we have to recognize that unless Stump's testimony is relevant to this trial, which is Helmsman versus Metrofire, unless Stump's testimony is relevant, it's not coming in. Why would Stump's testimony be relevant? Let's look at the case. Helmsman is suing Metrofire on an insurance claim. Tim has testified in a way that's injurious to Helmsman. Now, Stump is going to testify as to an out-of-court statement made by Helmsman, in which Helmsman told Stump that Tim had stolen some items from Helmsman. Stump further testifies that Stump had related this conversation to Tim. Tim had refused to discuss it, but Stump rent it to him anyway. How could this possibly be relevant in the context of this insurance claim? And the answer is, Tim is a witness. Helmsman is seeking to impeach Tim. Tim has testified against Helmsman. Helmsman is seeking to damage the credibility of Tim using the testimony of Stump. There is no other reason why Stump's testimony is relevant. So all we need to do is analyze Stump's testimony as to whether it's proper impeachment or not under the federal rules. What's nice about that is that there are really only three broad categories of techniques for impeaching Tim. Number one, we can look at Tim's capacity. We can attack Tim's capacity to function as a witness. Number two, we can attack Tim's past. Are there things in Tim's past that would suggest that he isn't credible? Number three, we can call a witness who knows Tim, who has an opinion of Tim's credibility, or who has some knowledge of Tim's reputation in the community. Let's look at these one at a time. First of all, with regard to category one, attacking Tim's capacity. That would be an attack on his basic competencies. Is Tim able to perceive, remember, and retell? Can Tim function as a witness? Stump's testimony doesn't speak to this. Stump isn't telling us that Tim is nearsighted. Stump isn't telling us that Tim has memory lapses. Stump's testimony doesn't go to Tim's basic capacity to function as a witness. So we can forget about category one altogether. Let's look at category two. Is Stump telling us something about Tim's past that would affect his credibility? The answer here is definitely yes. Now, the federal rules allows us only 4 types of inquiry into the witness's past. And essentially, we can look at bias, we can look at conviction of crime, we can look at specific instances of conduct that would impact credibility, we can look at prior inconsistent statements. Let's look at Stump's testimony and determine which of these 4 categories it might be admissible under. First, bias. Does Stump's testimony suggest that Tim is biased? And the answer is yes. Stump is testifying here that Helmsman had told Stump that Tim had stolen some items from Helmsman. Furthermore, Stump is testifying that Stump had related this to Tim. So Stump is essentially testifying that Helmsman had badmouthed Tim to Stump, and Stump had told Tim about this. So Tim would know that Helmsman had gone around saying bad things about him. This would give Tim a reason to be angry at Helmsman. This would give Tim a reason conceivably to testify against Helmsman. It goes to bias. Conviction of a crime. Is there anything in Stump's testimony that suggests that Tim has been convicted of a crime? Answer, no. Specific instances of conduct. Is there anything in Stump's testimony that suggests specific instances of conduct on Tim's part that might hurt his credibility? The answer is yes. Stump's testimony suggests that Helmsman has told him Tim is a thief. So if we believe what Helmsman told Stump, then Tim has stolen some items from Helmsman. Tim is therefore perhaps less credible. So we need to look at specific instances of conduct. Finally, prior inconsistent statement. Is Stump telling us that Tim has made a prior inconsistent statement? No, that's irrelevant on these facts. And to clean up, let's look at that third category. The third way of attacking Tim is to call a witness as to opinion or reputation for truthfulness. Here, Stump doesn't know Tim. Stump isn't testifying as to Tim's reputation for truthfulness. Stump hasn't formed an opinion about Tim's truthfulness. So the two possible techniques under which Stump's testimony is admissible are bias and specific instances of conduct. Let's look at them in reverse order. Is Stump's testimony admissible to prove the specific instances of conduct on the part of Tim that would suggest that he's not credible? The answer here is no, and there are two reasons. First of all, Stump is testifying as to an out-of-court statement made by Helmsman, in which Helmsman says that Tim stole the objects. If we're admitting that out-of-court statement for the purpose of showing that Tim stole the objects, in other words, for the purpose of proving those specific instances of conduct, Helmsman's out-of-court statement is hearsay, and it's inadmissible. So the hearsay rule presents one problem, but the rules of evidence present a second problem. Even if it weren't hearsay, you can't prove specific instances of conduct in this fashion. Let's take a look at Rule 608B. Rule 608B says, specific instances of the conduct of a witness for the purpose of attacking or supporting the witness's character for truthfulness, other than conviction of crime as provided in Rule 609, may not be proved by extrinsic evidence. Stump's testimony is extrinsic evidence. We can't prove specific instances of conduct by extrinsic evidence. What can you do? You can cross-examine the witness and ask about specific instances of conduct. What could Helmsman's attorney have done here? Cross-examine Tim. Ask Tim, did you steal the antiques? Did you steal the painting? If Tim says, no, I did not, it's over. You can't produce any further evidence on the subject. In particular, Stump's testimony is extrinsic evidence of those specific acts, inadmissible under the federal rules. Let's now look at bias. And the question is, under the federal rules, can Stump's testimony come in to show Tim's bias? The answer is yes, but you won't find it in the federal rules. The federal rules don't talk about bias at all. However, before the federal rules, there was the common law, and the common law allowed impeachment based on bias. In United States v. Abel, the question was raised whether impeachment based on bias is still possible under the federal rules. The court in that case said, we think the lesson to be drawn from all of this is that it is permissible to impeach a witness by showing his bias under the federal rules of evidence, just as it was permissible to do so before their adoption. So the common law continues after the federal rules, and even under the federal rules, impeachment based on bias is still allowed. Continuing from United States v. Abel, the common law of evidence allowed the showing of bias by extrinsic evidence, while requiring the cross-examiner to take the answer of the witness with respect to less favored forms of impeachment. What does this mean? Even though Stump's testimony is extrinsic evidence of bias on the part of Tim, it's admissible because we can show bias by extrinsic evidence. Bias is a very important thing. It's highly probative. We're allowed to use extrinsic evidence to prove bias. That impeachment technique permits extrinsic evidence, where the specific instances of conduct technique did not. Furthermore, Stump's testimony doesn't involve hearsay. Why? The statement of Helmsman, the out-of-court statement of Helmsman, isn't being used for its truth. If we're admitting it for the purposes of showing bias, we don't care whether Tim stole the items or not. We're not trying to prove that Tim stole the items. All we're trying to prove is Tim knows that Helmsman has badmouthed him. So we're admitting Helmsman's statement not for its truth, but simply to show that Tim was aware of it. No hearsay problem here. Stump's testimony does come in under the federal rules to show bias. That's why B is the correct answer. Now let's take a look at the incorrect answers. Choice C would say that Stump's testimony is inadmissible because it is neither opinion testimony nor reputation testimony. That's correct, it's not. That's why we can't use it for Category 3 impeachment. But we can use it for Category 2 impeachment. Choice D. Choice D would say Stump's testimony is inadmissible extrinsic evidence of a dishonest act committed by Tim. That's correct. It's inadmissible as extrinsic evidence of a dishonest act committed by Tim. It doesn't come in for impeachment by specific instances of conduct. It does come in, however, for impeachment based on bias. It only needs to come in for one reason. It comes in as impeachment based on bias.